A very good evening to all. I am Neelima Vinayar, Joint Secretary LJRF Trivandrum Chapter. I extend a warm and hearty welcome to each and every one of you to this webinar, conducted as a part of Human Rights Day celebrations. Human rights based on values like dignity, fairness, equality, respect, and independence have more relevance in today's circumstances in our country. Dr. Ambedkar, the father of Indian Constitution and a greatest supporter of human rights, has contributed his ideologies in our Constitution, which are capable of making India into a best human rights country. Even after long 70 years, whether as a country, we have been successful in implementing those ideologies is a serious matter requiring discussion and resolution. Today's webinar on constitutionalism, human rights, and Ambedkarite jurisprudence is conducted as a part of Human Rights Day celebrations by Law and Justice Research Foundation Trivandrum chapter in collaboration with Mandava Science Foundation Bangalore and Hindustan Institute of Technology and Science Chennai. Our keynote speaker for the webinar is Dr. Girish Kumar J, Assistant Professor and PhD Research Supervisor, Department of Law, Central University of Kerala. Today is the first day of Dr. B.R. Ambedkar Memorial Lecture Series, which we have planned to conduct each year. There will be 5 lectures in connection with the lecture series. It will be held on 5 auspicious days, that is December 10th, Human Rights Day, January 26th, Republic Day, April 14th, Ambedkar Jayanti, August 15th, Independence Day, and November 26th, National Law Day. Today, we have around 300 registrations in the webinar. We are expecting the rest of the participants to join us soon. Before moving on to the program, I would like to remind the participants to mute your microphone during the program. I request you all to cooperate with us for the smooth conduct of the program. So let us begin. For that, let us begin the webinar. So for that, I request Ms. Uttara, LJRF Trivandrum chapter member and third semester LLB student of Mar Gregorius College of Law. So welcome, Uttara.
Thank you so much, ma'am. So a very hearty good evening to all the participants here. Myself, Uttara, second year LLB student in Mar Gregorius College of Law and also a member in LJRF Trivandrum chapter. So we can move on to our today's session. To deny people their right to challenge, to deny people their human right is to challenge their very humanity, says Nelson Mandela. Human rights are the moral principles or norms that describe certain standards of human behavior and are regularly protected by law. Dr. B.R. Ambedkar, who is also called Baba Sahib Ambedkar, is one of the world's greatest defender and philosopher of human rights. He was a true visionary, contributing to a global evolution to the idea of human rights, and to this day, he continues to inspire human rights defenders. Today, we have all assembled here to be a part of the first session of Dr. B.R. Ambedkar Memorial Lecture Series, which is being conducted as a part of the Human Rights Day celebrations. Today's session will be on the topic Constitutionalism, Human Rights, and Ambedkarite Jurisprudence. Before we commence with our today's session, I would like to take a moment to appreciate our conductors, that is Law and Justice Research Foundation Trivandrum chapter, also in collaboration with the Mandava Science Foundation Bangalore and Hindustan Institute of Technology and Science Chennai. Once again, welcoming you all to our today's sessions. And I also like to bring into the attention of all the participants that make sure your mics are muted and none of you get engaged in any kind of presentations while the session is on for the smooth conduct of our sessions. To officially invite us all, I humbly request Advocate Chindu Joseph, President LJRF Trivandrum chapter and also a research scholar in Department of Law, Central University, Kerala, to welcome us all to our today's session. I welcome you, sir.
Thank you, Uttara. Am I audible?
Yes, sir.
Okay. Respected Dr. Saroja A.S., Dr. Girish Kumar J., Dr. Manivenkat Lakshman, Sri Daniel Prashant, LJRF State and Trivandrum chapter officials, LJRF members, members of Mandava Science Foundation, personalities from Hindustan Institute of Technology and Science, and all others who are presented here. A very good morning to you all. I feel honored to get an opportunity to deliver welcome in this Ambedkar Web Series 1, which is conducted as part of the auspicious Human Rights Day celebration conducted by the LGRF Trivandrum chapter in collaboration with Mandava Science Foundation and Hindustan Institute of Technology and Science. As we all know, Human Rights Day is observed by the international community every year on 10th of December. It commemorates the day in 1948, the United Nations General Assembly adopted the Universal Declaration of Human Rights. The principles incorporated in the UDHR are as relevant today as they were in 1948. It empowers everyone. It enables us to stand up for our own rights and also for the right of others. That makes every 10th of December a day of utmost importance to each and every living human being around the globe. Likewise, the theme of Human Rights Day 2020 is Recover Better, Stand Up for Human Rights. The theme relates to the COVID-19 pandemic and focuses on the need to build back better by ensuring human rights that are central to recovery efforts as per the UN. While talking about Dr. B.R. Ambedkar, being a person who has underwent plethora of discrimination, the various phases of his life, he recognized the importance of identifying and preserving the human rights. Ambedkar has chosen the path of thorns to fight on behalf of 9 crore untouchables at his time to emancipate them from subhuman condition to a position of dignity of person in the society. He led a relentless social reform movement to educate the oppressed of human rights, to live a life of dignity, and to organize them among themselves to vindicate their rights to self-confidence, self-help, and to agitate for civil and political rights. Thus, the Ambedkar Memorial Lecture Series does automatically will be narrating divinity and noble concepts of human rights. At this point, I would like to start welcoming the respected personality we have today with us in the webinar. To start with, today's presidential address will be delivered by the most honorable former principal, Government Law College, Trivandrum, Ernakulam and Thrissur, Dr. A.S. Saroja ma'am. Ma'am has always intimated her invaluable consent to be the part of activities and webinars conducted by LJRF without any hesitation. And I was lucky enough to be a student at Government Law College, Trivandrum during her tenure. On behalf of LJRF Trivandrum chapter, on behalf of Mandava Science Foundation and Hindustan Institute of Technology and Science, I extend my warm welcome, ma'am, to this auspicious occasion. Next, I would like to welcome today's keynote speaker, Dr. Girish Kumar J., Assistant Professor and PhD Supervisor, Department of Law, Central University of Kerala. And I personally feel much honored and happy to welcome him as he is my PhD Research Supervisor. A personality with academic profusion in multifarious academic areas and also the one who can be identified as a philanthropic. We can't get a better person to be with us to gain inestimable perspective on human rights. I wholeheartedly welcome Dr. Girish Kumar J. to this bright occasion of Ambedkar Memorial Lecture Series. Welcome, sir.
Thank you, Chindu.
Next, I would happily welcome Dr. Manivenkat Lakshman, Dean, School of Law at Hindustan University of Technology and Science. Sir has always shown his enthusiasm in associating with the events and programs conducted by the LJRF. He had agreed to deliver a felicitation speech in today's program, which is surely going to be an informative one. Me, on behalf of LJRF Trivandrum chapter and Mandava Science Foundation, wholeheartedly welcome you to the event, sir. Today we have Sri Daniel Prashant Sebastian, sir, with us for giving another felicitation speech. He currently acts as the Managing Trustee in Mandava Science Foundation, Bangalore. His eagerness in associating with the events initiated by LGRF is commendable and hopeful. I think this is his second webinar where he's going to share his valuable outlook with us. On behalf of LGRF Trivandrum chapter and Hindustan Institute of Science and Technology, I cordially welcome you to the event, sir. Finally, I welcome all the LGRF state and district chapter office bearers, members of LGRF family, members from Mandava Science Foundation, members of Hindustan Institute of Technology and Science, faculties, advocates, research scholars, other respectable dignitaries, students, and all other members who are attending this webinar with prime interest and spirit. Thank you, and it's over to you, Pira.
Thank you, sir. That was indeed a pleasing welcome. Up next, I would like to invite Dr. Saroja A.S., former Principal, Government Law College, Trivandrum, Ernakulam, and Thrissur, to give away the presidential address. She's also a well-wisher and advisor of LJRF. I wholeheartedly welcome you, ma'am. Saroja, ma'am.
Thank you. Thank you, and thank you very much. And a very good evening to all of you. First of all, let me congratulate the Law and Justice Foundation Trivandrum, the Mandava Science Foundation Bangalore, and Hindustan Institute of Technology and Science Chennai. So today we are starting the Human Rights Day celebrations, and this is the first lecture series. And today the topic is on constitutionalism, human rights, and Ambedkar right jurisprudence. So respected members of the LGRF, Advocate Chindu Joseph, Girish Kumar, Dr. Mani Sir, Dr. Daniel Prashant Sebastian, and Rosemary, and also the organizers of this webinar, the participants, and all the well-wishers of LJRF, Mandava Science Foundation, and the Hindustan Law Institute. First of all, I thank the LJRF for inviting me to preside over this function. Morning, I had associated with the Hindustan Law Institute, and I had to deliver a topic on human rights and women. I'm glad that I am proud and privileged that I get opportunity to preside over academic activities, especially those relating to law subjects, which has always been interesting and inspiring to me. And today's topic, human rights, constitutionalism, and Ambedkar right jurisprudence. Actually, it is a very interesting topic. And the starting in my presidential address, I would like to quote B.R. Ambedkar while drafting the Indian Constitution. He had made a quote saying that however good a constitution may be, it is sure to turn out bad, because those who are called to work it happen to be bad. However bad a constitution may be, it may turn out good if those who are called to work it happen to be good lot. So this is a very motivating and thought-provoking quote, which actually point to the fact that if our intentions are good, if our motives are good, however bad a constitution, we can work it out to be a good constitution. So I think LJRF is doing that kind of work, bringing motivation, inspiration, interpreting the various provisions in law, or guiding the young lawyers and students in the right path. So I congratulate the LJRF in making a path-breaking effort to motivate young lawyers and students to be the lawyers of future. Congratulations, LJRF. Now, coming to the topic, we all know that the Indian Constitution, which came into force in 1950, it was a significant event not only in the political history of India, but also in the history of social justice and human rights. See, that is where the topic human rights also is relevant today. But at the same time, it has opened up new avenues of human welfare and development in the Indian subcontinent by providing equal rights and privileges to the citizens at large. So the Constitution of Independent India was meant more than a mere legal manuscript that is likely to structure the norms of governing as well as define the sanction of various key institutions and political actors. So India gained the status of free and sovereign nation in 1947, August 15th. And we all know the struggle, the long struggle we had and the countless sacrifices. And the constitution which was adopted in 26 November 1949. So here, the history, I'm not going to go into the history. I just want to highlight how Ambedkar had played a relevant role in bringing or drafting the constitution. He is the architect of the Indian constitution. See, constitutionalism is actually different to the constitution, as it is merely not confined to the constitutional text. It takes us back to the past as well as the future of its exercise. So constitutionalism is not all about governance, as it also provides the contested ideas and practices concerning justice, right, development, and associational autonomy. And it is commonly conceived to be the idea that there are legal restraints on the exercise of political authority. So the main task undertaken, as I want to do in this particular presidential address, is that it is necessary that both constitutional and constitution and constitutionalism that never exist together. See here, for instance, I want to tell you the Constitution of India gives great importance to the right to freedom, which is given under Article 19 to Article 22. But an individual, even if he does have a right to choose his life partner freely, which is mostly evident, we can see the honor killings, which is happening all over India. This fact can be further observed in the various prevailing religion-based, caste-based, the lineage-based customs and practices, which have continued in violating the basic right of an individual in the post-colonial society. So, though we have the freedoms which is written at large in the Constitution, fundamental rights, no right is absolute. Restrictions can be placed on those rights. And even those freedoms where we can exercise it in such a way that the inalienable rights, that is also in certain cases violated in such a way. So constitutionalism and constitution, that is my personal view, it can never exist together. And another thing is that the constitution in India has been framed in such a way in the post-colonial period. It makes endeavor to fulfill those expectations which were created by its people while they were under the yoke of its Britishers. So while presenting the draft constitution to the Constituent Assembly in 1948, Ambedkar maintained there was nothing to be ashamed of and borrowing, because nobody holds any patent rights in the fundamental ideas of the Constitution. Perhaps this is why the creators of the Indian Constitution took inspiration from both domestic and foreign sources. We can be very proud to say that our constitution is the biggest, bulkiest document in the world. That is, we have copied all the good articles or the provisions which existed in other countries. And so Ambedkar doesn't feel any sad or ashamed of borrowing. So we have borrowed important provisions from the Indian domestic sources as well as foreign sources. And Ambedkar had very commitment for the social causes, as it was explained by Chindu Joseph. Ambedkar was a person who underwent a lot of discrimination during his childhood and during his growing up age. So he saw to it that this is not repeated after the constitution came into force. And so he devoted many of the provisions wherein discrimination is not made on the basis of religion, caste, sex, or any other kind of that is any race-based discrimination. So he succeeded to arrange certain provisions in the Indian constitution for ensuring justice to the oppressed sections and creating a just society. So in other words, the Indian constitution challenged the dominant conceptualization of justice, equality, and welfare in the post-colonial Indian society, which disregard a bulk of the populace, in fact, needed it best. So I want to say that Dr. Ambedkar, who chaired the drafting committee, is notably considered as the father of the Indian Constitution, and he played a pivotal role in the constitutional making. I don't want to take much of the time in my presidential address because we have a very important speaker for this particular topic, Mr. Girish Kumar. Before concluding, I want to say that the chief draftsman, that is B.R. Ambedkar, he played a very significant part in the process of constitution making. He raised the voices of those who had been long remained unheard and had an intense commitment for the social cause and upliftment of the deprived and downtrodden sections of the society. He explicitly mentioned in many of the provisions about swear which he took for the elimination of unjust, inhuman practices from the Hindu society in the context of untouchables. And he was a representative in the Constitutional Assembly of all downtrodden sections in general and untouchables in particular. And he proudly proclaimed himself the leader of the latter. See, here we can consider him as the pioneer of the notion of affirmative actions and inclusive policies. He took the responsibility to ensure justice and dignity to the low caste of the society. And Ambedkar advocacy, as we have said, Ambedkarite jurisprudence, the concept of the constitutional morality further emphasized this fact, by which he proposed to drastically change the extremely hierarchical and social order, whereby every aspect of this was controlled by the higher Hindu caste. So Indian constitution does incorporate the social and political philosophy of Ambedkar, which is most noticeably evident in the various provisions of the constitution. See, we don't have to go anywhere else. The preamble itself, the eye opener or the intention of the constitution is very clearly spelled out in the preamble. And preamble part 3 and part 4. Preamble part 3, part 4 and part 16. See, all these shows the unity of the country and safeguarding the important the concepts which the whole constitution stands for. And Ambedkar gave much priority the principle of equality and liberty and fraternity. And for him, it is necessary to ensure equality in our social and economic life at the earliest possible to solve the problem of the what do you call the discrimination that existed in the Hindu society at that time. So these principles, equality, liberty, and fraternity, see these doctrines we can see throughout the thread in the constitution, and wherever you go, this has stood up, and wherever this is violated, we are allowed to challenge it by going to the Supreme Court and the High Court. So, and on the other side, there is also an irony that the practice of exclusion, that is continual denial of constitutional rights and privileges, equality of opportunity and basic necessities, as well as the vicious exploitation of the people belonging to the lower caste in the society, that has resulted in a number of cases of what you call the Dalit atrocities and the violence against Dalits. So, with these words, yeah, even today, see, these incidents do occur. We are all witness to whatever is happening all over India, and we also read it in the daily newspapers. The atrocities reported against women, against the often the untouchables, and the Indian state and the institution has actually somewhat failed to live up to the ethos of its democratic constitution in general, and especially the philosophy or the vision which Ambedkar had in mind when he drafted the constitution. So the social relation between the caste and the subcaste groups are still prevailed, especially among the higher caste Hindu society and the scheduled tribe sections, which are struggling to get equal status, or the deprived classes. So, what we can do by holding a seminar, it is not possible to do away with the atrocities which is happening in our society, but at least in our personal life, we can uphold the principles and constitutional ethos which Ambedkar stood for, and particularly devoted to the principles of social and economic justice and non-discrimination, liberty, equality, and fraternity in our personal life. Each of us who are participating in this webinar, we can take an oath, we can take a sphere before this audience that at least we will not create this kind of what do you call discrimination among our groups. So keeping this in mind, the growing cases of caste division which is happening in our society. So to my opinion, the vision of Ambedkar is yet to be realized. It is not at all, even 50% of it is not realized. And it is the task of governing elite to the efforts to achieve it. And we can be a part of the governing people to uphold the principles for which Dr. B.R. Ambedkar stood for. Thank you. Thank you very much.
Thank you so much, ma'am. Your words are indeed enlightening. Up next, it's indeed an honor to invite our keynote speaker, Dr. Girish Kumar J., Assistant Professor and PhD Research Supervisor, Department of Law, Central University, Kerala. I wholeheartedly welcome you, sir.
Thank you, Uttara, and thank you everyone assembled here. It's really an honor to be part of the efforts taken by LJR. Dr. Safi Mohan sir has been constantly talking to me about his endeavors. I was watching by virtue of having the academic leadership he is taking in the Government Law College Trivandrum. He didn't stop his work inside the classroom of the law college, has gone beyond that to reach people in every walks of life by formulating an organization and thereafter doing many such efforts like academic seminars, interventions, field studies, etc., on a day-to-day basis with an outstanding team of young students and researchers. I congratulate my dear friend Dr. Safi Mohan and all the team members for materializing this kind of events every day in the academic format, even regardless of or in spite of the COVID-19 lockdown problems we are facing. And thank you, Chindu, for your kind words of introduction to me. And thank you, Saroja ma'am, for the presidential address. And the topic assigned to me today is constitutionalism, human rights, and Ambedkarite jurisprudence. All the three words in this title, according to me, are rather misunderstood or misconceived. In the meantime, I request the organizers to play the PPT I have already forwarded to the team. We can straight away go to the contents of the presentation and I can talk like this, and quite often or occasionally people can also respond. So I just allege that all these three words are rather mistaken or misunderstood or misconceived. So when I told so what I meant was constitutionalism is misunderstood as a term or a practice or a principle or a way of doing things which are to be followed by people practicing law or other legislative process or judicial process only. Even people inside these processes, judicial process or legislative process or whatever executive process, in accordance with the provisions of the Constitution, even such people do not every time follow the constitutional principles. Because people misunderstand that Constitution is a legal document which is to be taken care of inside the courtroom or inside the legislative hall or inside this kind of a seminar room only. The principles and ideals put forward by the Constitution is left behind when people leave for the street or other fields of life where the constitutional principles and constitutional ideals which are put forward or which are envisioned by the framers of the Constitution are violated on a day-to-day basis. Then human rights. Human rights also is a rather misconceived word. The terminology originated by the introduction of the Bill of Rights in American Constitution, then Universal Declaration of Human Rights. So people across the globe have been talking about equality, and we also misunderstand that by talking about human rights, in our country also we can materialize the concept of equality, which is a very distant dream. Human rights is otherwise also misunderstood as a set of principles which are to be taken care of by properly placing the textbooks in the almirah or shelf of the library and beautifully articulating about its principles and values and ideals when we are inside an academic seminar room or a classroom. In a country where human rights of the common man in the street are violated on a day-to-day basis, our misconception about human rights, the basic human rights principles, also are at very much fault. Then comes the term Ambedkarite jurisprudence. It is very much unfortunate that even academically big people in this country are having the misconception that Dr. Ambedkar has been a leader of the Dalit or untouchable people of this country only. So when Ambedkarite jurisprudence, the term is coined, people start to think that it speaks about Dalit rights, it speaks about anti-discrimination laws, it speaks about untouchability, it speaks about reservation, and reservation which is taking away the right or the opportunity of the majority or the people belonging to the unreserved communities or categories. So these misconceptions, actually Dr. Ambedkar has attempted during his entire life is to uphold the principles of or the ideals of liberty, equality and fraternity, which are not unfamiliar to the world by then, which was introduced to all of us by the principles governed or ignited the French Revolution. Dr. Ambedkar has been trying throughout his eventful life to ignite the activities and thoughts for promoting liberty, equality, and fraternity. However, he too had been branded as a Dalit leader, and his jurisprudence has been termed as a Dalit topic of Dalit rights or reservation jurisprudence. Unfortunately, it was the plan, it was the deliberate plan of the elite leaders of the political India of those days to brand and to sideline Dr. Ambedkar by merely branding him as the Dalit leader or a leader of an oppressed section or a small section of the society who must argue for abolition of untouchability and abolition of discrimination. So I start from the premise that majority of us unfortunately have got misconceived these three terms: constitutionalism, human rights, and Ambedkarite jurisprudence. So what can be done for correcting the historical error we have committed? I'm inviting your attention to some principles which had been promoted or always put forward by people like Dr. Ambedkar. Please move on the slide, my dear friend. Vishnu Dev, come on. See, the constitution was prepared by borrowing from many sources. Our dear Professor Saroja ma'am has already told you, and otherwise also, we are told many times that Indian constitution is a composure or a mix of almost every acceptable ideals from many democratic constitutions and many other sources. So the committees constituted for suggesting the contents of the constitution also had been an integral part of contribution to the constitution. So there was an argument during the Constituent Assembly debates that Indian constitution has nothing original. It was borrowed from some or the other source. So we can just go to see the argument and counter argument that way. Come on, Vishnu, we can proceed. See, Government of India Act 1935, we all know. It has been the primary source of the Constitution of India. And the allegation was this Constitution is borrowed mainly from this Government of India Act, and the rest of it has been borrowed from constitutions of other countries of the world. But Dr. Ambedkar had to coin the term constitutional morality in reply to this argument. Come on, Vishnu, we can move. due to the late hours we are presenting, we may be moving in a bit fast manner. My dear friends, please bear with it. And if you have anything to ask me or anything to raise as an observation or clarification, please interfere and please interrupt me in between. See, his reply was, there is nothing wrong in borrowing because a constitution of a country or people who make the constitution of a country should be ready to study and incorporate the good ideals existing in other constitution because no constitution is coming out of thin air. By the time India has been making its constitution, many democratic nations of the world had already put in place their own constitution. So it was so necessary for a country like India, where democratic ideals were largely unknown for centuries together. It was very much necessary for such a country to borrow from acceptable sources, and the team framers of the constitution had to take care of that task by borrowing from acceptable sources. How can we make a good constitution? That was the biggest challenge. And he had coined the word constitutional morality, which was already in existence by Professor Groth. I will come to that. The constitutional morality, just like the term constitutionalism, see, we started from the misconception. Constitutionalism is not keeping the constitution inside the courtroom or classroom or legislative hall. Constitutionalism is following or developing a lifestyle by following the ideals you have told in your constitution. In whatever relations, not only in fiduciary relationships or not only in formal relations, even in your family setups, your domestic relations, you should be following some ideals. You should be democratic. Even if you are not able to give a big lecture on democracy, if you are democratic enough in your domestic relations with your spouse, your children, your parents, your friends, it is enough for identifying an element of constitutionalism or an element of democracy within you as an individual. So, constitutional morality, as Dr. Ambedkar has suggested, is the skeleton of the constitution. It had given you an indication, a guidance as to which way this country should go, which way this country should move. And from the ideals developed through laws and policies and the experience, the historic experience of the society, the values of tolerance, love, care, everything, truth, humanity, fraternity, liberty, equality, independence. We give, or we are supposed to give, flesh and blood to that skeleton. Constitutional morality translates to greater obligation on the part of state authorities to conduct themselves. State means the nation. To conduct themselves in accordance with the constitution instead of behaving like feudal overlords. Because I had to use that term, I had to take that term from Dr. Ambedkar's writings only by the strong reason that our country was never been having a democratic history. It has been having an oppressive history, a dominating history, an undemocratic history, a kind of feudal history, a discriminatory history, a history of disparity, a history of deprivation, oppression, and suppression or exploitation. So such a country had to look forward by learning lessons from its past and to move like a jaguar, regardless of the other kind of morality a morality which is away from constitutional morality. Maybe it can be collectively called your public morality, maybe the product of your religion, your geographical origin, the group or the family, the surroundings you belong to. So the morality, the principles of morality you gain from all these sources are to be refined. It should not be used as a raw. It should be refined and it should be added to the constitutional morality, the skeleton, to give it flesh and blood. Unfortunately, our country had always witnessed a conflict or an invisible fight between the constitutional morality propounded by the framers of the constitution to guide the country in a democratic path of liberty and the public morality of the people or the majority of this country, which are governed by the religious and many a times narrow or kind of intolerant kind of morality. Come on, Vishnu, we will move. The idea of constitutional morality has been subject to different interpretations and often to the vagaries of socio-political environment. We all will agree with that. Because there is a concept that transformative constitution, an ideal constitution is not a static one. It will get corrected from experiences, natural law theory. My dear law students may be familiar. Natural law theories on one side says that people learn from their mistakes and experiences and they get the indication as to what is right and what is wrong from the nature. The natural process is guiding them. On the contrary, you have seen the Augustinian jurisprudence suggest that law is not the product of nature, but law is the command of a sovereign, which need not be democratic. In both these concepts, there is an element of change always deep-rooted or inbuilt. You can see constitutional morality also keeps changing. Constitution keeps changing not in the sense that a textbook of the constitution is rewritten every other day. No. The concept of constitutional morality, what was right or what was legally right or what was thought to be constitutionally permissible has got changed over the period of time. And in the future also, that there only you will be reminded of Carl von Savigny's observation about static societies and dynamic societies. The sociological jurist Carl von Savigny has rightly remarked the importance of keeping pace with the changing times for every society. So laws are the tools, according to him, for changing the society. So a formal built society, not about social change. The change of societal change and social change are two different things. Societal change is the formal change, reform initiated by legal instruments and policy changes, which on a day-to-day basis reforms a modern society. But social change is the change in the attitude, in the practice, religious or other kind of conventional or conservative modalities of the people, which are to be changed by changing the mindset of the people. Mindset of the people cannot be changed by law, you all know. We had Untouchability Abolition Act, Article 17 in our Constitution, 14, 15, 16, everything. We had plenty of legislations like the Protection of Civil Rights Act, the SCST Atrocities Prohibition Act, Dowry Prohibition Act, many such legislation, but very much miserably failed to generate change in the mindset of the people. So, The term transformative or transitional must be kept in mind, and the idea of constitutional morality has been subject to different interpretations. You can see conceptual essence of the constitution, while some of these core principles cannot be altered. Some concepts, basic concepts may not be altered, but some concepts you can see from the recent judgments. One is cited here, Navtej Singh Johar, in which section 377 of IPC has been taken away. The public morality has not been ready to accept same-sex marriage or sexual attraction between people of same sex. But a constitution which promotes or which is asking you to promote and uphold the principle of equality, liberty, and fraternity will very well ask you to change your mindset. But even in such a situation, it is very difficult for the society to change because society may think that, of course, we need this constitution or we need this law, this human rights principle, that human rights principle, everything. Wherever we require it. Beyond that, we don't want it. So when a policeman just catching hold on your collar, or when he is taking you into custody without having committed any offense, you need the law to protect you, you need the human rights principle to protect you, you need your constitutional right to protect you. But when a judicial authority or the legislature is coming with a law which is designed to abolish the inhuman practice you are following as part of your conventional religious belief, you will say, no, it is not the domain of the constitution. It's not the domain of the legislature. It's not the domain of the court. It's our belief. It's our faith. The constitution has nothing to do with faith. The constitution has nothing to do with belief. The constitution has nothing to do with religion. So this attitude of the society, which is not open for change, is a big challenge. We can see Sabarimala judgment, when women were allowed to enter Sabarimala. People have been using the term faith repeatedly. No, the court has no domain there. The legislature has no role there. It is our belief, faith. So even if you practice discriminatory activities, even if you practice inhuman activities sometimes as part of your faith or religious belief, you don't want the legislature or the judiciary or the constitution to step in there. But when you are met with a violation of basic human rights of you by another agency, you very well need to have the constitutional principle or the legislative intervention or the judicial process to come for your rescue. This is a big challenge. Okay. We are coming back to the principle of constitutional morality, it being the guiding spirit to achieve transformation within the society, therefore becomes relevant for considering controversies as wide in scope and as far reaching in consequences as issues relating to manual scavenging, hate speech, surrogacy, same-sex marriage, and same-sex adoption. Manual scavenging, only one instance in the Indian society's history, which was thinking and believing and which was underlining for centuries together that it is the traditional occupation, it is the trade of a particular sect of people in this society. They are destined to do that. Other sections of the society are meant to make this section do that profession. But the law had to interfere. and the work by many people, organizations have to interfere. Hate speech. So when something happens over the internet, you see these days cyberbullying. When you say something unacceptable, you are attacked by cyber goons. And when you criticize the government policies, you are booked with the sedition law. The law will catch hold of you, and it will come with the allegation that you are speaking against the state. So does it mean that you are not you have no right to speak against the people who rule you? If the ruling people are wrong, you don't have any right to point out that, because the answer lies in the term democracy. People come to power through the democratic process, but the moment they acquire power, or the moment they occupy the chair of power, which is the product of the democratic process, they start ignoring, or they start forgetting the principles and ideals of democracy. So coming back to the principle, come on Vishnu, we can move on. Constitution versus religion, always a burning topic, always a bone of contention, always a topic which is subjected to heated arguments, disagreements, and disruptions, even walkouts. I don't know how people can walk out from an online platform. People may simply walk out. But when you speak about constitutional religion, I request my friends gathered here to accept one side, whether you are going by the side of constitution or by the side of religion. People may say that I am a strict follower of constitution, but my faith is integral part of my identity. I am religious also. But your faith says you, not your fault. I am not alleging that you are at fault. Your faith, your religion, your tenets, your testaments, your Gita or Bible or Quran or whatever is the document. If your religious document says you or asks you that you have to keep this much feet away from that person, and on the other side your constitution, the constitution on your left hand, or in your pocket, tells you not to keep away from the person but go in hand with the person. What will you follow? What you are supposed to follow? So that's why I requested my dear friends gathered here to take one side. It is very much challenging and it is very much strugglesome to be constitutional as well as religious at one point of time or simultaneously, or to promote constitutionalism as well as your religious practices in the same time. Why? Because religions are not the products of any democratic or constitutional processes. Maybe there may be good elements in religions, I agree with that, and all of us can agree. And every religion, are speaking about love, care, humanity, truth, compassion, of course. But the $1,000,000 question is, to what extent your religion is ready to practice this equality or this love within itself? Inside your religion itself, people are placed differently. The clergy or the priests are the uppermost layer. Then the middlemen in the clergy are in the middle layer. And the rich people who can fund the clergy or fund the institutionalist religion will be the next layer. And the common man who may not be able to fund the religious institutions, but maybe following the faith or believing the God in the lower level, lower layer. Every religion, no religion is an exception. No religion is an exception. So my point is, there is nothing wrong with a follower of religion, but there are many things wrong with the religions. And it is very difficult. You may think that, so we can reform religions, we can correct religions, and we can go hand in hand with religion as well as constitutional values. Very difficult. People have experiences wherever people have attempted to reform religions from inside or outside. They had to pay the prices. And even societies, when attempted to reform religions from within and outside, they had to pay the price. The history of civilizations of humans are proof of that. You can start thinking or watching from the Renaissance period in Europe in the 18th or 19th centuries. So coming back, my dear friend, what if an act ratified by the society or the religious tenets of its community? Please, Vishnu, go back for a while, please. Previous slide. What if an act ratified by the society or the religious tenets of a community is antithetical to the moral concepts innate in our constitution? This is the million-dollar question. A learner of law or a person obeying the rule of law of the country may sincerely think that in such a situation I must go by the constitution, but he cannot go back home in the evening if he takes such a hard decision. Because when he leaves his office and moves his home, there comes religion, there come beliefs, there comes your faith, there comes institutionalized religion, there comes the priest, the clergy, everything and everything. You have to go by the religion only. In that kind of, you can go by the religion only. So instead of waiting for religion to reform itself, or instead of laboring after reforming religion painfully, we have a very easy way out. That keep our religious faith or our beliefs as secondary when it comes to the constitutional ideas of truth, humanity, liberty, equality, or fraternity. A very difficult task, but if practiced, will realize or will take us a long way in realizing the dream of the makers of the Constitution. Justice Saroja, our learned Professor Saroja ma'am has rightly remarked Dr. Ambedkar's dream has yet to be realized. So we have to move on for that direction. It's 6 o'clock, I think. Can I prolong the speech? It's up to the audience. Normally, I don't prolong speeches like this. So if everybody is ready, we can move a bit more beyond this. Come on, my dear organizers.
Please, sir. Please continue.
How much time I can take? Any idea?
No, sir. It's completely up to you. They are patiently waiting to hear the rest of the session.
You are putting you in a risk by giving me the license to take away your right.
Sir,
Supremacy
but
of the
considering the
Constitution.
fact that you are an expert in human rights law, we do have confidence in you that you will be taking care of our rights too.
Okay, we will try our level best to take care of the human rights of everyone gathered here. Supremacy of the Constitution. Can we consider Constitution as supreme? In legal textbooks or classrooms or academic seminar rooms, we are able to agree. But in the street or on our way to the temple or the mosque or the church, are you able to agree that Constitution is supreme? If that had been supreme, we would have never witnessed a Sabarimala judgment and the resultant collapse of the constitutional machinery problems in the streets. If we are ready to accept Constitution as the supreme document, of our country, we would have avoided or done away with many problems which we have encountered. Because the judiciary, as the last hope of a common man, is coming or interfering in between, coming once in a blue moon or one quite often and giving some judgments that law is against equality, that practice is against equality. It should be taken away, and you should go by equality. You should go by liberty, and then only we people are reminded of the importance of the term equality or democracy or constitution. Otherwise, we may always say that constitution is supreme, but when it comes to choose between alternatives, our consideration of supremacy will be taken away by something else. So it is a very much big lesson we have to learn. Constitutional supremacy should not rest in the paper only. It should reflect in our practice, in our day-to-day life. Whatever we hear, whatever situation we are exposed to, the very first moment our mind should be tilted towards the concepts or the ideals promoted by our constitution. Then only the term constitutionalism can be said to be properly understood, properly conceived by the society. Come on, Vishnu, we can move on. Supremacy of the constitution, that modality is not limited to the mere observance of the core principles of constitutionalism as the magnitude and sweep of constitutional morality. It is not confined to the provisions and literal text which a constitution contains. Simply, I can tell you this observation of Deepak Mishra Justice in Navtej Singh Johar, where Section 377 of IPC is taken away. It is not merely following what is literally said in Constitution. Then the problem is, you can say you are a strict follower of the Constitution, but you are not open to change. You have to, even before the Constitution becoming open for the change, as an individual, the individual should be ready to change. And he should feel the change. And he should suggest that the society also should change its attitude. What was considered wrong yesterday should be right today and should again be wrong tomorrow, and day after it may again be reversed. So, the constitutional morality is a dynamic process. The concept of supremacy of constitution doesn't mean that you are sticking on to what is literally told in the constitution only. You should be reading beyond that. The literal, beyond the literal language of the constitution, the meaning, the intention. When you read the preamble, it is said that it should open the minds of the makers. What was the intention behind the making of this constitution? When you read a provision, you should be able to understand the intention behind that provision. So in a different situation, you will be able to apply the principle differently in accordance with the need of the hour. Okay, come on, Vishnu, move on. Vishnu has gone.
No, sir, I already did.
At least the person who is moving the slide should be there till the end of the program. In a constitutional democracy, people are not mere subjects of law passed by an unquestionable authority. Rather, they are masters of their rights. Clear? I don't think there is an explanation. People are not to be remained at the receiving end in a constitutional democracy. They are to be responsive. But be careful. When you be responsive to the system, to the policies, there is every chance for you to land in jail. Always be ready for that. because there is a sort of Damocles, that is a sedition law or the IT laws or whatever kind of laws used to by the law enforcing agencies to book you when you speak against government policies, when you criticize. Your right to protest and dissent is always at stake in the growing democracies everywhere, not only in our country. Don't think that our country only is vulnerable. In the post-truth era, my dear friends, you may be aware of the term post-truth because truth is not relevant in post-truth era. In the post-truth era, you are not concerned about whether, the people are not concerned about whether you are telling truth or falsehood. The world is just focusing on your capacity to establish what you say, to substantiate what you say. You can even come with a lie, but if you are able to beautifully establish the lie, you are the leader of the post-truth era. We'll discuss that in some other time. Fundamental rights and the rule of law had life outside of the constitutional text, that Indians had a right to life and personal liberty, irrespective of whether it appeared in Article 21 of the Constitution. And inroads into that right could not be made except under the authority of law. Even without having 21 in the Constitution, people have the right to life and personal liberty. That is Justice Khanna's opinion, habeas corpus case. Many of you may be aware of or may be reminded of Justice Khanna. There is an important observation about Justice Khanna, who has wrote or who has told in a private meeting that last night I have written a judgment which may cost me the Chief Justice of the country. So Justice Khanna is a judge of the Supreme Court who dared to write a judgment which he had every reason to believe may cost him the Chief Justiceship of the country, and that happened. You can go back to ADM Jabalpur and Indira Gandhi, Rajnara and everything. I'm not into that. You all, many of you may be aware, and we can come back to that afterwards. But the essence of his statement here in ADM Jabalpur's case, that inroads, any intervention upon Article 21, right to life and personal liberty, shall be made except under the authority of law. With the legal authority only, you can come to touch this liberty path, right to life and liberty. But it didn't stop there. The judicial process has added. So this doesn't mean that with a law you can always violate the right to life and personal liberty. No, the law should be just, fair and reasonable. Please be reminded of Maneka Gandhi. So supremacy of the Constitution is a mindset, is an understanding, is a readiness to accept, is a willingness to accept our right as well as another's right, our duty as well as another's duty, our space as well as another's space. Okay, come on, Vishnu, move on. Vishnu. Vishnu is the god for sustenance. Srishti Sthiti Samhara. Sthiti, you have to be there always to take care of our space and our sustenance. Ambedkar and constitutional morality. See, gentlemen, ladies and gentlemen, the Constitution only contains legal provisions. Always we are aware of the fact that it is only a book containing a set of papers. And how can it come to the street and save human rights? Or how can it come to the field and obstruct violations of human rights or protect the basic rights of the downtrodden people? Because it can do that through the people who are supposed to practice it. So there comes the importance of constitutional morality and the concept of democratic state. Even though the state is run by the majority, because democratic electoral process always speaking about democracy, the majority. Even though the state is run by majority, the interest of even the minute minority should be taken care of. A majority rule should never leave the room for fear in the minds of the minorities that they are unsafe. Whether we are able to generate that confidence in the minds of every section of the society is another question we must ask to ourselves. We must introspect and retrospect. Come on, Vishnu. Vishnu Dev.
Sir, I already changed the.
But
Sir, I guess Vishnu is facing some network problems. Kindly pardon us for the same. He's trying.
you have selected the right person to move the slides.
Sorry, sir. It's because of some
When we
network
read
problem.
what is
We
the
do.
supremacy of constitution, then okay, we are moving to the concept of constitutional morality. Dr. Ambedkar was not a mere politician. See, all of you will agree or not, I don't have an idea. But one thing is sure that majority of people amongst us brand Dr. Ambedkar as a leader of the untouchables. But he has been, because it is our duty, it is the duty of each and every Indians to tell the world as to whom Dr. Ambedkar has been. And whom he has been is a very big question. We must understand first ourselves and then to tell the world. He has been a pioneer of liberty of people, a pioneer of individual liberty, equality, and fraternity. He was born in a community which lost its sense of freedom and which subordinated itself to the holy sanctions of the priestly class. They considered themselves to be impure, unholy, and subordinate. You all will agree, I know. Because some societies are living in bad destinies by their own beliefs and their own manner of acceptance of their destiny. Dr. Ambedkar has been coming from such a section of the society, but he didn't limit himself to be the leader of a particular section only. He never wanted him to limit himself. But the elite leaders of the country those days wanted to limit Dr. Ambedkar as a leader of Dalits only, which is a historical error we have to correct. And you know, this particular, you can see, jurisprudence promoted by Dr. Ambedkar. It contemplates a constitutional morality which is deep rooted in the principle of fraternity, the sense of brotherhood, and three ideas. I am not going to read it in entirety. Three things I am again highlighting: equality, liberty, and fraternity. And you must also analyze it whether the question is all these three, can these three stand apart? Take each one. Liberty without equality, what would be the result? Some people in the upper layer will be having liberty, and people of the lower layer never, maybe. That is the problem of liberty without equality. And equality without fraternity. Fraternity means you are interacting with people in hand. Having the elements of untouchability in the society and speaking about equality, how can it be proposed at least? No, there will be the principle of equality. There will be equality among people of a different class. They may not be having any relation with the other section. Maybe they may be equal inside the class, but there will be class discrimination or class division. So these three terms, liberty, equality, and fraternity, must go in hand to attempt the objectives put forward by the principles of constitutional morality and democracy, which the Indian constitution had been always attempting to promote, which the Indian society unfortunately have always been struggled and miserably failed to uphold and promote to a great extent. If I am wrong, please correct me. Now we can move on, Vishnu. Again, Vishnu is stuck with the slide. Ambedkar jurisprudence is based on the Trinity principles of equality that we have already dealt with, and preventing discrimination. We have the legal provisions, the constitutional provisions here, but everyone is aware of the fact that mere placing of provisions inside the constitution or the document of law won't be able to change the society. The introduction of Hindu Code Bill during Dr. Ambedkar's tenure as the law minister of the country, you may be knowing that this was actually an attempt to reform the Hindu religion from within by means of a law. And you have seen how miserably that law has failed. So we come back to the only answer available to the question, or the only solution available for the problem of discrimination, historical discrimination in this country, that is constitutional morality. Constitution should be kept in mind properly, and people will not be merely keeping the constitution as a textbooks in the bookshelf only. People won't restrict the constitution within the seminar halls or academic discussion rooms or classrooms or courtrooms or legislative halls. Freedom would be of no sense if people are permitted to be divided into classes. So in different classes, there may be freedoms within, but there may not be coexistence. There may not be brotherhood. And there will be further limitation of the freedom. You know that see, America is claiming to be a free society. It has been claiming so even before the abolition of slavery. We all have seen. The American Constitution has been propounding equality, liberty, everything. But the practice of slavery has been a part of the American way of life. And the same way we cannot also think about or talk about or claim that we are upholding liberty or freedom without removing the caste-based discrimination, the inhuman religious practices, and the gender bias and the gender discriminations within the religious structures in our country. Please come back. Ambedkar is a model in addressing the issue of division and discrimination with the help of law. There is a question whether he was right in believing that by the tool of law, the discrimination inside a particular section of people can be removed or not. But that was an attempt. That's the reason which inspired him to consider the historical temple entry declaration in the state of Kerala as a recognition of a legal right, not of a religious right. There is another question whether by entering into a temple, whether the downtrodden or the untouchable sections of the society has earned everything, because they are never offered anything from within the temple. But Dr. Ambedkar has viewed that this temple entry proclamation, even though they are not getting anything big from inside the deity temple, they are not even getting anything materially from the temple. this is a symbolic kind of gesture, which is giving way to have a recognition of a legal right to equality, even though it is a very small step. Okay, then it doesn't stop with discussion there. Mere granting of rights without an enforcing procedure to protect the same cannot be fruitful, and this we created a place for Article 32. All these rights had been explained in the Constitution. Vishnu, are you able to move the slide? If okay, you move on. I'll tell you called it as the heart and soul. Come on, move on. Soul of the Constitution of country. Why? Because is we have taken time at length to explain, to elaborate, and to underline, to underscore, to articulate on different rights and different dimensions of each and every rights, basic human rights of the people at length, as Madam has suggested, the bulkiest constitution of the world. However, without providing a strong enforcing mechanism, all these rights would have left in paper. So this thinking paved the way for bringing about Article 32. Come on, Vishnu, move one more slide. Yeah, 32, which according to Dr. Ambedkar has been the heart and soul. What is happening is Vishnu is moving a slide and he presses the key again and again. So slides are not properly understanding Vishnu. That is the problem. The problem of artificial intelligence versus intelligence. This remains as an unaccomplished value. A bloodshed revolution had to be avoided. It was the dream of Dr. Ambedkar. Through a constitutional process, a democratic rule of law, the country can witness a revolution. Revolution means a thorough change from one system to another. And Dr. Ambedkar's view was that without a bloodshed revolution, that change can be brought about, and mainly with the help of legal instruments starting from the constitution of the country. But we are still half the way. Come on, Vishnu, move on. Time is going very fast. I'm reaching 6:30. I have to stop. Come on, Vishnu. As the most popular statue of Dr. Ambedkar, his statue is having the Constitution on his one hand, and the other hand is pointing to infinity. So this Constitution must be kept in hand to move through the right path for social change, political change, and the societal change, and the practicing of equality, liberty, and fraternity. See, the day when all the differences end up through love and brotherhood, that is envisaged by the fraternity principle of the Constitution. Both fanatics and subaltern will transform into human beings, and the vision of Ambedkarite jurisprudence on the basis of fraternity will be fulfilled. So the supremacy of the Constitution, that is the point I want to raise in this evening, and the point I want to register in the minds of all my dear people gathered here, is the supremacy of the Constitution. It need to be reaffirmed by the courts and legislature by acting as agents of justice with their eyes placed on the constitutional morality. The living, transformative, and constitutional text, a living, transformative constitutional text, very important expression. It must be always active. It must not sleep. A constitution, an ideal constitution must not sleep. And it must always be acceptable to change. It must be open to change. And such a constitutional text only can save the country or save the people from oppression, but it alone can never be. We all know that everyone has to play his or her role in keeping the dynamism of the constitutional morality and in promoting the values of the Constitution. Come on, Vishnu, we can move a bit more. Caste is not a notion, it is a state of mind. The destruction of caste does not therefore mean the destruction of a physical barrier. It means a notional change. We come back to the temple and recognition. By opening the temple gate, caste is not destroyed in the country, but it's a symbolic gesture. The people should open the gates of their minds, and it is a kind of way of practicing things. Caste is a mindset, and discrimination is a mindset. If you are ready to practice liberty within you, within your surroundings, you will be able to understand the importance of practicing liberty around you. If you are not able to practice liberty and to respect the liberty of your fellow people, your right to claim your liberty will also always be weakened. Okay, if this is correct, then obviously the enemy you must grapple with is not the people who observe caste, but the shastras which teach them this religion of caste. Dr. Ambedkar didn't attack people of upper caste who practice untouchability. He instead attacked the shastras, texts, and testaments which made these people observe these untouchability practices. So what is to be destroyed is not the people, not the physical barriers, but the basic texts and tenets. Or even if you are not there to destroy the tenets and textbooks, you have to correct, you have to remove the errors from within, which is a very difficult task. So I'm very happy in this evening in speaking to all of you about the importance of correcting the historical errors happened in our society by branding or terming Dr. Ambedkar as a mere Dalit politician, and by terming or by misconceiving the term constitutionalism as a matter of observance of constitutional principles inside the courtroom or legislative hall or a classroom, and the misconceived notion that human rights are beautifully protected by articulating the great human rights documents around us. All these errors are to be corrected, and human rights are to be practiced without any compromise. See, towards the end, I can tell you morality, constitutional morality is not mere reading of a constitution textbook from cover to cover. Constitutional morality is keeping in mind the ideal of constitution and constitutionalism in running a nation in a democratic way by practicing the ideals of tolerance, liberty, fraternity, love, care, acceptance, and affection within and outside our surroundings. So, thanking all of you and welcoming any suggestions or any kind of queries or observations in this evening to enrich my knowledge as well as the discussions happened this evening. Come on. Thank you.
I request the participants, if you have got any doubt, you could clear it with our speaker.
I have a question. Can you all hear me? I'm Diksha Sharma. I have a question.
Yes, Diksha, we can hear you. Please.
Bringing such wide perspective towards constitutional morality and the Ambedkar right jurisprudence towards constitutional morality, it was definitely enriching. My question is, We have seen that constitutional morality has recently been employed by the apex court as the guiding spirit, as you mentioned, the guiding spirit to interpret fundamental rights. Is it different from,
So,
or it's a means to achieve an end, that is rule of law? And sometimes I feel that we have been using the term constitutional morality to replace or as a synonym to rule of law or constitutionalism. So it is kind of confusing to understand constitutional morality in the context of rule of law and constitutionalism. Can we say that people, this has been used as a new wine in the old bottle called constitutionalism and rule of law? And how to differentiate between constitutionality and other concepts like rule of law and constitutionalism. I hope I'm making some point here.
so Diksha, you want to differentiate between constitutionalism, constitutional morality, and rule of law.
Yes, precisely.
See, constitution, we can say constitution is the mother, and rule of law, constitutional morality, everything are the children. See, constitution in the beginning we have discussed about the observation of Dr. Ambedkar that the constitution as a document is only the skeleton, and the morality the public gather, the morality the public create, the society create should add flesh and blood to it. So a constitutionally acceptable morality, one can say, is the constitutional morality. If you come with 10 sets of morality, which is the product of your way of life, your tradition, your religion, everything, and the constitution is able to accept or ready to accept only 2 sets out of it and rejecting the 8, so these 2 sets can be considered to be constitutional morality. So rule of law is not a separate or a different term. It is also a related term. Constitutionalism to constitution means we are observing constitution, we are respecting the ideals of constitution, we are running our society in accordance with the constitution. That is constitutionalism. Rule of law is we are obeying law. Law means it can be within the constitution or outside the constitution. Enactment, legislations. We are running the country in accordance with the laws, we are obeying laws, we are observing laws. That is rule of law. Related terms only. And the constitution is the mother of all these. So better to start your thinking right from the constitution and move slowly through the concepts of constitutional morality, rule of law, democracy. Democracy, without a constitution, democracy cannot be in place. People may say that there were even pre-constitutional societies have been democratic. There may be some models of electing the leaders and governing the society by the leader. No, it may not be that much democratic in its true sense or spirit. A constitutional scheme only can guide a democratic process correctly. So democracy, rule of law, constitutional morality, everything is the byproducts of the constitution. And constitution is the very important or supreme document, and our acceptance of the document as the supreme one can be termed as constitutional supremacy. Okay, a very big topic for discussion, but we have to confine to the time. Come on, anyone else? Okay,
Thank you, sir. Thank you. I got it.
yes,
Sir, good evening.
come on. Happy to see the almost student.
Yes, sir. Yes. Of course. Thanks. Yes. So I have a little bit confusion that we are having a society with what we would say having a moral diversity, and I believe that the constitutional morality lies in recognizing this moral diversity. But what we are receiving is a judicially fashioned version of the constitutional morality. whether it be the case of a interaction between the people of same sex or the case of a religious faith, whatever it may be, what the people are receiving is what is the judiciary decides whenever, especially in the case of a moral question arises. So whether my concern is that whether this is undermining this the concept of constitutional mandate of the moral diversity.
See, I will give you some practical examples, Divya. I will try to give. See, as a learner of law, as a student of law, after listening to a 1 hour lecture on liberty and equality, if you in the evening, if you go to a temple by reason of your religious belief, where some people are kept out of the gate, it is wrong. And as a teacher of law, after giving a 1 hour lecture on constitutionalism, rule of law, democracy, and liberty, if in the same evening you go to a temple to offer your worship to a god in a temple premises where some section of the people are kept outside of it, you are wrong. And as an individual, after speaking about the constitutional morality, the liberty, the freedom, the equality for hours together, if you go home and ignore the necessity of practicing liberty within your household, you are wrong. So it is a very difficult and or complex issue. Some people may always say that I am impartial. I am not standing by his side or that side. I am trying to see things impartially. But these people never know how difficult or how strugglesome is to remain impartial in a system. So I apprehend Divya's point is that even by practicing religious beliefs and religious ethos or ideals, one can be constitutionally moral. One can uphold constitutional morality. Is it your point, Divya?
No, that not that, sir.
Divya is.
Yes, but actually, what I want to make it clear that in a whatever may be the issue, but especially when a issue relating to morality, that is public morality, comes, the one part alone is protected. That is how the judiciary interprets it. That will be the result. The rest, sometimes we are forced to accept the morality, which is not, which may be against our moral inclinations. So how the judiciary plays, what is exactly what I understood that?
See, in that situation, in Divya, in that situation, people should be ready to accept their own mistakes. That if the constitutional morality is acceptable, but the one person may be ready to accept that the public morality I have been upholding was wrong. But we are unable to do that. That is the problem. And it is very difficult. We may hope and pray that we can balance, or we can just the simultaneously we can promote both public morality as well as constitutional morality. It may be a dream only. It cannot be that easily approachable or achievable. Very difficult task, because we are modern citizens. We are not merely touched by the rule of law or democratic process of the country at some points of time only. We are touched by this, or we are obsessed by these principles all over our life. So it's very difficult to keep these principles at one corner of our mind and to have a kind of holy kind of faith or religious kind of ideals on the other part of our mind. It's very difficult to balance these two, because one side you have the epitome of discrimination, other side you have an argumentative individual against discrimination. Very much difficult position. Okay, very happy to see that our participants are coming prepared and raising very important points. And they never mind the time also. I'm happy about that too.
So actually, we are running out of time, so it's necessary that we should conclude it as soon as possible.
I am always ready. I have actually reminded of I have reminded of you, the organizers, about the time, and they gave me the license to continue. But I stopped. But I feel that some people also may be raising some points. And if at all anyone needs to interact, we can, or else we can go to the concluding mode. And my email ID and mobile numbers will be shared, and this organizers and my all of them are my friends or students only. I'm always available for taking forward this discussion beyond this virtual platform. Come on, back to the organizers.
Okay,
Thank
sir.
you
Thank
for
you
the
so much for your truly.
opportunity once
Thank you.
again.
Truly. Actually, thank you for your truly informational words, sir. Moving on to our felicitation program. For the felicitation speech, I invite Dr. Mani Lakshman, Dean, School of Law at Hindustan Institute of Technology and Science, Chennai. I welcome you, sir.
uh, of the bearers of this forum, dignitaries, and the participants, dear students, and other all dignitaries who are participating, including the presenters. It's a very significant day today because human rights day. You know the importance and all that. We know how the United Nations long years back, in 1948, has enacted the provisions of a code of civil, political, and civil rights and economic and social rights. And then much has flown, as our previous speaker was talking on constitution and constitutionalism and functioning. And as far as Dr. Ambedkar is concerned, he is the soul and spirit of the Indian uh, thinking. That is, he was able to bring about a very great concept of equality, Article 14 and Article 19, 21, and all these things which we are enjoying today. And as a matter of fact, even despite of the problems we are facing, I mean, judicial as well as practical, as has been taken in regard balancing of the morality by the constitution as well as the courts. We are much in success because compared to some many nations, the constitution does not function at all, or they are going in the different directions. There's constitutional failure. India is a country which has not so far seen any kind of constitutional failure so far, and we are very much balancing despite of our problems. And it's a very big topic which has to be discussed in detail. And due to the timings involved, I'm not going to a great speech. And I wish the Law and Justice Forum all the success for their all the activities ahead. And I wish that this day be cherished in a great manner. Thank you. And I'll be talking in detail in another occasion. Thank you. Thank you very much.
Thank you so much, sir. Up next, I also invite Sri Daniel Prashant, Managing Trustee, Mandava Science and Foundation, to speak a few words in our felicitation speech. I welcome you, sir.
Switch on it. Sir, your mic is not in on mode. Your voice is not coming, sir. Microphone is off.
Issue with this network. Hello, sir. Can you hear me? Prashant, sir. Hello. I think our speaker has got some issue with his network. So
No, no,
moving
no.
on to the
No. Actually, he hasn't switched on his mic. That is the problem.
Okay, can you hear me now?
yes, sir. Now you're audible.
Okay. Okay, I'm gonna go with my device speaker on mic. I hope it is clear enough. Is it fine?
Yes, sir. It's okay. It's fine, sir.
Perfect. So, okay. Hey, thanks for bearing up with me for this moment. Good evening all to all the dignitaries and the stalwarts of the legal fraternity and friends who've gathered here this evening as we grace this celebration of Human Rights Day by inaugurating Dr. B.R. Ambedkar Lecture Series, especially the first series of all. Many congratulations from Mandava Science Foundation to Safi sir, LJRF team, and all the other dignitaries who've joined today in making this a grand event today. So here are a few thoughts. I'm sure, like most of our legal fraternity experts have touched upon, and I'm sure we all know as to why we needed human rights first of all, because we are just for a simple reason because we are humans, and more of it, it also embodies the key values in our society such as fairness, dignity, equality, and respect. They are an important means of protection for all of us. So it gives us a protective layer as we all come together as humans. So, and many other points, like I'm sure, like most of them have touched upon more in detail. Probably I can just skim through, like ensuring people's basic needs, protecting vulnerable groups from abuse, allow people to stand up to societal corruption, or encourage freedom of speech and expression, gives people the freedom to practice their religion or not practice anything at all, or even allows people to love who they choose, encourage equal work opportunities, give people access to education, protect environment, or provides a universal standard that holds governments accountable also. So the question is how did it start from, or where did it start from? A short story on human rights is the belief that everyone, by virtue of her or his humanity, is entitled to certain human rights is fairly new. Its roots, however, lie in earlier tradition and documents of many cultures. It took the catalyst of World War II to propel human rights onto global stage and into global conscience today. Throughout much of history, people acquired rights and responsibilities through their membership in a group, a family, an indigenous nation, a religion, a class, community, or state. Most societies have had traditions similar to the golden rule of do unto others as you would have them do unto you. So the Hindu Vedas, the Babylonian Code of Hammurabi, the Bible, the Quran, and the Analects of Confucius are five of the oldest written sources which addresses questions of people's duties, rights, and responsibilities as we talk today. In addition, the Inca and the Aztec codes of conduct and justice and an Iroquois constitution were Native American sources as well that existed well before the 18th century. In fact, all societies, whether in oral or written tradition, have had systems of propriety and justice, as well as ways of tending to the health and welfare of their members. So it always came as a protection, a layer of protecting the existing, humanity as a community, in fact. And so the evolution of human rights. So since, like Mani sir said, as well as Girish sir said, as well as Saroja ma'am brought up, yeah, since 1848, when the Universal Declaration of Human Rights has served as the foundation of 20 human rights conventions. Many human rights conventions have entered into force. Some are still in the progress of ratification. Others, such as Convention on the Rights of Indigenous People and a Convention of Environmental Rights, are still even being drafted. So this is going to be an ongoing thing. So like Dr. Girish sir said, it is not going to be a static thing. It's going to be constantly an evolving situation. the human rights organization has always been looked as, most of the time, it's been looked as a reactive agent, not because of its inability, but for the amount of evolution it goes through before they get codified as binding law, or human rights concept must pass through a lengthy process that involves consensus building, practical politics at an international level, national level, state level, even to the lowest demographic that we can look at. So when we look at all this, then it can all come true and come to life only with experts and enthusiasts like Ambedkar in those days, and many Ambedkars that we come across, like Dr. Saroja ma'am, Girish sir, who so profusely spoke about. I could see the love in his work for Constitution and the Constitution rights when he spoke only. Moni Venkat sir. Especially, I can't stop mentioning Safi sir as well. So we are hoping to see many changes to come in the days that we are seeing. It is such an honor to be amongst these stalwarts and experts like you. And I have to mention this day, Safi sir has been a great philosopher, a great mentor, and an excellent human being and a good friend of mine. We are proud to be partnering with its first lecture series organized by Law and Justice Research Foundation. So we hope we will be able to conduct the next year's Ambedkar Memorial in a large auditorium, and also hoping Corona is gone by then. Safi sir, we wish you more such events to come through, and LJRF as well. And you can be rest assured that Mandava Science Foundation will continue to support you in all your endeavors. All the best again, and congratulations for all the team here.
Thank you so much, sir. Now that we have come to an end of our today's session, I now invite Ms. Rosemary Sibi, Secretary, LGRF Trivandrum Chapter, and Assistant Professor in CSI Institute of Legal Studies, Trivandrum, to deliver the vote of thanks. I welcome you, ma'am.
Thank you, Udra. Thank you so much. When I say equal rights for all, I mean equal rights for everybody from the very beginning of conception until natural death. So it was really a refining session which enlightened us with broader aspects relating to human rights, constitutionalism, and Ambedkarian jurisprudence. So we mark this Human Rights Day, or we celebrated this day by marking a beginning of Dr. B.R. Ambedkar Memorial Lecture Series. First of all, I would like to thank Dr. Saroja ma'am, former principal of various government law colleges. Actually, she gave life to the formation of our constitution and the role of our great legend, Dr. B.R. Ambedkar, in making history. Ma'am, before thanking you, I should say, as you called for or as you asked for, we won't be fair, actually. We won't be indulged in any discriminatory activities, at least personally, I should say. Thank you, ma'am. Thank you so much for your kind words. Thank you. Now, our attraction of the day, our keynote speaker, Dr. Girish Kumar Gilkar, Assistant Professor and PhD Research Supervisor of Department of Law, Central University of Kerala. Actually, I would say Sir has blessed this occasion with his charming personality and delightful work. And I think he showed us a different phase of Dr. B.R. Ambedkar and helped us to remove a lot of misconceptions that is prevalent in the society. Thank you so much, sir. We are really obliged to you. Thank you so much. Now,
Thank you, Rose.
thank you, sir. Thank you. Now, Dr. Mani Venkat Lecture, sir, Dean of School of Law at Hindustan Institute of Technology and Science, Sri Daniel Krishnan Sebastian, Managing Trustee, Mandava Science Foundation. Both of them have also made this occasion very informative and interesting. We are really thankful to you two as well. Delighted to for your presence as well. So thanks to you both. Now, as the final remark, I would say I would express my heartfelt thankfulness to the members of LGRF, the coordinators and joint coordinators, the mentors, especially and the technical committee, and also my co-supervisor, and who delivered the welcome address, Chindu Joseph, Advocate Chindu Joseph, and also my dear fellow participants. You are the core strength of this program for making this celebration, for making this program really wonderful. And thanking you all, thanks a lot, and wishing you a happy Human Rights Day. And I really wish all your rights be protected every time, and make sure that you also protect others' rights. All right, thank you. Thank you once again. Uttara, over to you.
Thank you so much for heart it's giving. Thank you so much for that. And now we declare our today's session officially over, and thanking each and every participant for your valuable time and here.
Thank you all. Thank you, Sapi sir. Thank you, Visruth. Thank you, Mani sir. Thank you, Chindu. Thank you, Mariam. Rose Mariam. And thank you, the
Thank you, sir. Thank you once
Thank you,
again.
sir.
organized team.
Thank you so much, sir. Thank you.
Everyone.
Thank you, sir.
Everyone here. Thank you, Sarojama. Thank you all.
Thank you, sir.